welcome once again to Ewtn's Bookmark. I'm Doug Keck, your host. Our guest author, Dr. Gatdula. His book, Natural Law and the Limits of Judicial Power. It's published by Central Books. It's great to meet you, Doctor, right here on Bookmark. First time here to talk to you about this book, but people would recognize you from having been on with Father Mitch,
yes,
talking about natural law, right?
Yes. This was a great conversation. We spent time discussing the impact that natural law has on society and how our turning away from it for various reasons did not exactly benefit society as a whole. And we could see this not only, for example, in my country, the Philippines, but also obviously in the US and other countries.
Right, it's interesting. You are over here from the Philippines. What positions do you hold over in the Philippines?
Oh, I'm the Dean of the Institute of Law of the University of Asia and the Pacific. I'm also a columnist for a newspaper there, the leading business newspaper, Business World. And I'm also with the Philippine Judicial Academy, where I assess and train judges, members of the Philippine judiciary.
Okay.
Yeah.
Well, let me ask you the most important question. Who's Karen?
Oh, well, she's my first wife and the mother of my daughter, Lucia, who's here right now. She died out from a long battle with cancer, quite bravely, I have to add. And so I felt that it was just appropriate, of course, to dedicate the book to her. She was with me ever since we were classmates in law school. And well, this is also essentially her book as part of the struggles we had through law through the years.
How long did it take you to put the book together?
Actually, a fair bit amount of time, because the actual writing was probably around a couple of years, 3 years. It was also part of my dissertation when I was getting my PhD. But it has been there lingering since from the early part of my career because of what I have observed with regard to our Supreme Court and how it behaved. And so there you have it.
So you say in the beginning, confronting the Philippines are numerous social issues of an intensity not seen in the past, trying to come to terms with its beliefs, its values within the world of fluid politics, cultures, norms, and especially you also have it on top of the idea of dealing with numerous islands. We don't always really think about the, the topography and geography of the Philippines. Do you see a lot of those similar issues happening elsewhere in the West, including the United States?
Well, geographic, I think, surprisingly, probably is the same. With regard to my experiences here in the U.S., differences in values, particularly with regard to the coast and then the Midlands.
Good point,
so even though, for example, we're not similar in the sense that the Philippines is an archipelago, but I think the issues, the differences, the debates are almost quite similar. Unfortunately, so. I remember, and I was telling this to Father Mitch earlier, when we have political differences, it all boils down, for example, with regard to whether taxation should be increased or not, whatever policy with regard to, for example, labor and all of that. Nowadays, the issues essentially boil down to how do we appreciate reality. And it becomes really...
How do we appreciate reality?
Yes.
Explain that.
Well, some people actually... well, all of us before, for example, whether it be Democrat or Republican, and in my country, whether it be, for example, you're for Marcos or for Aquino, people would essentially have those type of differences, whether we go here, left or right. Nowadays, it becomes impossible to have a conversation because whereas before we had a similar set of framework, we had a similar set of, let's say, a basketball court that we all play in.
The same set of rules.
Essentially, yes. Right. And nowadays, that thing is practically gone. So it's really important. I mean, it would have been similar to the fact that it's like having a cell phone signal wherein the signals come and go. Now we practically are living in a world where the signals are actually different for each people.
I see.
And it's incredibly...
Different frequencies people are basically living on.
Exactly, and so it's quite difficult to have that conversation.
So they talk past each other. What's interesting, you say here, knowing that a country must share commonality or risk not being a country at all. You're talking about thus the environment surrounding this study on the natural law and its role within the Philippines legal system. You see that certainly in the United States as well, because we are and have been in the past a melting pot. We kind of moved to this mosaic idea and a heavy emphasis on this identity politics, which ultimately at the end of the day pulls people apart and makes them separate, right?
Yes. Well, I don't really know what to add from what you've just said, but I take my beliefs also from this writer, Roger Scruton.
Oh,
the
right, the Englishman. He
Yes,
just died in the last couple of years, right? Didn't he,
almost at
right?
the same time actually as my wife.
Oh, right. Yeah.
Well, the thing here is that we seem to want to have a world where there are apparently there are no countries, that John
One
Lennon,
world kind of thing. Yeah.
idea.
Imagine.
Yes,
Right.
but in the end, no. I mean, we do have an attachment to a certain place. We are human beings. We are bound by a certain attachment to time, to place, to people that we know. Hence the commonality with regard to culture. Obviously, with regard to our families as well. And so, to pretend that such attachments do not exist is really doing no benefit to anybody.
Right. You see, natural law or its intellectual tradition plays an inherent function within the Philippines constitutional system, and yet such is either misunderstood or denied outright. Now, we hear in the United States about natural law, and there seems to be this sense, at least, that you gather that at one time that was kind of like the guiding light, certainly for the United States, but over a period of time, whether it's positive law or other things, have come in conflict with it. Is that the same idea you're dealing with in the Philippines? And if so, why is the natural law so important, especially in some ways as Catholics?
Well, actually, I'd probably defer a little in the characterization with regard to the role of natural law vis-a-vis the United States. I think there's possibly a thought that there's a divine law, and you could probably see that in the Declaration of Independence and so on. And then later on, you would have the school bus rulings, which essentially made a certain separation. Then the insertion of the idea of separation of church and state came in. With regard to the Philippines, I think the reason why I'm trying to insert or make people recognize the idea of natural law is because of the fact that there's really without it, the possibility of having a united front legally that would bind our society as a whole will become a very difficult thing to hold tenable. There's a certain difference in the way the United States Constitution is drafted vis-a-vis judicial power and the way the Philippine Constitution is drafted. Okay. And the United States Constitution essentially becomes a discussion on the differences between political questions and legal questions. In the Philippines, with regard to the 1987 Constitution, the latest version that we have, that distinction has become blurred. And so the justices have now had an opportunity, whether or not they accept that opportunity is something to be discussed perhaps later on, but the thing is that the distinction between the legal question and judicial question has been blurred. Whereas before you have questions that normally would be addressed only by the Congress, which are policy issues, and the judiciary would only address themselves to legal issues. And that's why you have a court that's usually only composed of lawyers, because of the fact that the function is really limited to legal matters. Because of a certain phrase inserted in our Constitution, which is the grave abuse of discretion clause.
Right, you comment on that throughout the book.
Yes. Right. What happened is that the justices now have an opportunity to essentially correct or even reverse our Congress, because in their belief, whatever measures that the Congress had done would constitute a grave abuse of discretion. Now, there are textbook definitions, and I mentioned that in the book: arbitrary, despotic, tyrannical, and so on. Right. But in real life, those definitions would really not serve as a really defined way to be able to ensure that what the justices are doing is essentially in line with what the Constitution is. Because what's arbitrary for you may be different for me, and what's tyrannical, and so on. And so that is one of the purposes of writing this book, and that is to put some sort of a fence or parameters within which the justices, our judiciary, can be able to make their function, the judicial function, be more appropriate and in keeping with the rule of law.
You say the primary aim of this study is to determine whether or not the 1987 Constitution contains an intrinsic framework that limits the expanded power of judicial review. So you're a lawyer, you're a dean in a law school, and your concern is the lawyers are getting out of control in judicial review?
More than the judiciary could run out of control, could go out of control, and with that...
Or abusing that phrase to maybe expand out their ability to change what
in the sense that they would probably engage in legislation, which is a function that they're not given.
Right.
As I said, if we were to look at the Supreme Court, for example, our judiciary, and say that, well, okay, fine, why not engage in policy? If you have Congress, for example, and let's say they're not composed of the most intellectual people on earth, then why not allow the Supreme Court, which is composed of 15 lawyers, our Supreme Court, and allow them to be able to correct whatever it is that the Congress has done. But that's not exactly the wisest thing to do, because of the fact that through the years, through millennia, we know that the separation of powers is an effective form of driving tyranny out, and to allow a certain group of people to have a function that was not given to them by the people in the first place. I mean, the citizens of in the first place, is putting ourselves in a precarious position, in the sense that if you give, and we saw this during the COVID lockdowns, if you give a certain group of people powers that they never actually had in the first place, it becomes very difficult for them to surrender those powers. And so that's the same principle here.
Yeah, well, absolutely. You talk about, and let's talk a little bit about the format of the book. You say after the introduction, part one, which expounds on the assumptions, reasons, and concepts underlying this study. Then you have part two, provides a review and examination of the Philippine Constitution. 3 and 4 constitutes the core of the book. And the former deals with natural law, its history, and its principles. The latter then discusses the reasons why the natural law framework is indeed embedded in the '87 Constitution and should therefore serve as an appropriate judicial parameter for deciding cases involving grave abuse of discretion. So I'm assuming there must be a large group of people who don't agree with you.
Well, yes, you're assuming correctly.
Okay.
Yeah. Well, right now the Supreme Court is, and I think one of the criticisms that has been leveled against it is perhaps the same criticisms that was leveled against the Supreme Court before the Trump appointees came into power.
Right. Okay.
So you're looking here at a bunch of a group of lawyers that may be sincere in their thought that when you look at the words of the Constitution, it should be essentially considered as manageable and should be responsive in accordance with the times. And the thesis that I hold here is that you can't do that because it essentially is undemocratic. To quote the words of Scalia, perhaps, okay, fine, let us assume that
Antonin Scalia, the late
justice,
Catholic justice.
Yes.
Right.
Let us assume that the Constitution is outdated. Let's assume that the Supreme Court has the wisdom to be able to interpret the Constitution in a manner that will be more in keeping and giving measures to the people that will be responsive to their needs. Nevertheless, who makes the call that the Constitution is outdated? And that was not a function that was given to at least to our members of the judiciary, and I know it's not the same function given to the members of the U.S. judiciary. In fact, it's such a departure from the original way that the Constitution looked at judicial review powers. It has been extremely expanded because of the fact of the Marbury decision, which we adopted as well in the Philippines. And so, yes, but the thing with the Philippines is that it has such a close, I mean, people can't really fathom how close the relationship of the Philippines is to the United States. And I have to say that whatever the United States does, you could probably depend on the fact that around 2 quarters later, 6 months later, the Philippines may probably adopt those measures. And Father Mitch was asking me earlier, what would be any measure or event that could happen that could probably result in the Philippines, for example, adopting measures relating to the sexual orientation, gender identity
laws. You talk about your concerns in the front of the book about that.
Yeah, same-sex marriage, and also with regard, for example, to transgenderism. And my answer to him was simple. If Donald Trump wins, then perhaps we have a chance of fighting this out. If he loses, then perhaps this is going to be more difficult for us. Simply because of the similarity in our system, the similarity of our culture, and our constitutions are actually quite similar as well.
Sometimes they used to say the United States coughs and the rest of the world gets a cold. Or something along those lines.
Yes, and it's
that's
quite
more of a ripple effect than we realize. Now, you mentioned Scalia. So are you an originalist, or is that only appropriate understanding for like a United States Constitution?
No, because of the similarity of our Constitution, I have no problem with being called an originalist. And I believe it is indeed the more appropriate way of looking at the Constitution. Because if people want to be able to say that, okay, fine, the Constitution is outdated, well, first of all, there are the principles there that are embedded. And that's why I say there are inherent things that are there that you could look at as a proper framework for our Constitution. But at the same time, if an amendment has to be made, then it should not be the Supreme Court making that amendment. It should actually be given back to the people who authored the thing in the first place, and therefore that's the proper thing to do. So.
And it's important for people to realize that basically the Constitution is designed to define and limit the power of the government as a way of protecting the people.
Actually, that's the thing, and that's one thing I actually have to correct with regard to perception, even from my own country and even for my own law students. When you look at the Bill of Rights, the Bill of Rights is not directed to us ordinary citizens. The Bill of Rights is actually directed to the government.
Right.
That if you want to be able to take away life, liberty, or property, then these are the certain standards or things that you need to do first. Yeah, that's true.
Now, you talk about here, it's kind of interesting in looking through the history before you get into the section on natural law. Was kind of interesting to me. You talk about the pre-Spanish era, the Spanish era, and then also the American era, etc. Because how many different constitutions technically have you had?
People probably, depends on the counting. So you probably have around 5. I mean, I peg it around 5. We're counting here the Malolos Constitution, which is the one that President Aguinaldo had. And then you have the 35. Depends if you count the constitution that was done during the Japanese era.
Okay, so that was, I'm assuming, controlled by the Japanese.
During the Second World War.
Right.
And then you have the 73 Constitution.
Is that basically Marcos?
The Marcos years.
Okay, right.
And then you have the most recent one, which is 87.
Right.
Now, in between 73 and 87, you had the 1986 People Power Revolution. In between 86 and 87, there was what you call the Freedom Constitution, by which essentially President Aquino ruled by fiat.
Okay.
So it depends on the counting, but more or less you probably put it at
So what was the biggest difference or change from the 73 Marcos Constitution to the 87 Constitution?
In the 73 Constitution, we basically followed the French model, where you have a presidential, a parliamentary form of government with the president. So Marcos was the president, but I'd like to think that the parliament essentially worked. It saves us a lot of money rather than having a second house in the system. It just so happened, perhaps, that it didn't work in the sense that there was really no distinction between the parliament and the president. President Marcos, the first President Marcos, was such an incredibly dominant figure that in the end, whatever claim to constitutionalism he may have had, and he was a very clever lawyer. Essentially was set aside because of the sheer force of her personality and his incredibly tactical mind with regard to politics and approaching it. So,
you talk about in the introduction here as well. To put it more directly, in the absence of an objective standard in which all acts can be measured against the determination of whether a certain act amounts to not only an abuse of discretion, but also a grave one, lends the possibility of such becoming highly subjective, depending on who the judge or justice is involved is.
Yes,
right.
And we've seen this. I mean, we've had an issue before, for example, wherein in order for you to be a president, to run for the presidency of the Philippines, you have to be a natural-born citizen. And there was an issue, for example, in one politician that we had who was a foundling, and who needed to do something, an act, in order for that politician to be considered as a citizen. Now, our definition of a natural-born citizen is that anybody who does not need to do an act is automatically a Filipino citizen. With regard to that particular politician, there was a need to go through a process to determine whether or not that person is indeed a Filipino citizen. Now, the text of the Constitution is clear, and yet we had to go through the entire legal process considering the fact that the Constitution is already clear. So again, that is just one example of that if we do not have a particular framework, a fixed standard, the legal system will just essentially go whoever is probably the most dominant justice or personality that is sitting on the court. So,
how many justices do you have on your court?
We have 15. So
has that number changed over time, or has it always been 15?
Well, in the 87 Constitution, it's 15. I mean, other constitutions that we had previously would peg it at around 11, and then it became 15. So in order for you to change a congressional act, you probably need around 5 lawyers, 5 justices. So if you have a quorum of 8, majority of 8 would be 5, and then that would be enough to overturn the vote of around 224, 275 members of Congress. So.
Do you have to be a lawyer to be on the court?
Yes, and that's one thing I've been emphasizing, because some people are saying that, well, we give it to the Supreme Court. We should allow them the latitude to be able to make policy to correct whatever it is that Congress has done. And some people see it as a way of circumventing Congress, which sometimes tends to be in deadlock. But the thing is here is that, and this is the wisdom of the U.S. Constitution, which we were able to adopt, because if you really wanted a body that is engaged in policy, then why limit it to 15 lawyers? Why not allow, for example, people like, for example, in business, in media, the academe, and so on, people of varying of backgrounds who could be able to shape up that policy. But we already have that body, and that body is called Congress. So why the need to duplicate it with regard to the Supreme Court?
Do you have, we also have here, at least in the States, a lot of this executive orders and things that seem to get done that seem to allow the executive branch to kind of bypass Congress, and then maybe the judiciary gets involved in reviewing it later. Is that something that the Philippines experiences, or not so much? Well,
we do have executive orders as well, but I think it's a little bit more rigidly controlled from what I've observed. From what I've observed regarding in the U.S.
Right.
So executive orders will essentially be issued only if there's a legislation already done by although of course in the Marcos years he was just really writing law by himself.
He was the law, wasn't he?
Yes.
Effective.
Well, the first Marcos, yeah.
Right. That's the one I was thinking about. Was he a general originally? Was Marcos a general? Ferdinand Marcos?
No.
He wasn't a general. He was just a.
He was a lawyer.
He was a lawyer. Okay, I heard you say he was a lawyer, but I wasn't sure if he was also a general. I was trying to remember. You talk about a whole third part is about natural law, the history of natural law, the rights of natural law. What is natural law, and why does it matter so much?
Well, it's an objective standard of right and wrong that we can arrive at by the use of intellect. It is also another way of saying it. Represents an intellectual tradition, which we can trace probably all the way up to the Greeks, at least the natural law that we are talking about right now. As Father Mitch also pointed out, natural laws can be present. You can see it in Islam also, the laws on Hammurabi and other traditions. But so it's an intellectual tradition by which we can pinpoint what is good, bad. What are the human goods that we need to be able to value, without necessarily relying on scriptures, and so.
So you're not making a religious argument.
And that is actually one of the I think the beauty of natural law. So.
Right. Now, if you talk about natural law, and you're also talking about the idea of positive law, which is that the same issue that you have basically in the Philippines we have in the United States, as a perspective of where the law comes from or what can justify the law?
Well, we do have positive. Well, obviously we have positive law because of Congress.
Right.
So I presume you're asking with regard to the tension between positive law and natural law, and we've had that.
Right.
I think the more spectacular example would be during the first Marcos years, wherein if you look at the constitutionality of his martial law, the Supreme Court actually upheld that. But I think everybody knew that there was some sort of immorality in having such a tremendous amount of power concentrated in so few people for such a long duration of time. And so I think there's an acceptance in the Philippines, and definitely that's clear, that there's such a thing as a higher law.
Right.
And now some people may have some disputes on what that higher law is.
Right.
My argument in the book is that higher law is a natural law. It's a natural law tradition that you have your founding fathers, we have our founding fathers as well, and I have been able to look at their writings, their speeches, and all of that, and they do believe in a natural law tradition. Now, one of the reasons why I had to describe the history of our Constitution from the Spanish era and up to the American era is to show that this thing is not essentially a product of the recent times, that from the very beginning, from the very instant the Philippines actually became Philippines, we already had in our legal system an understanding, an acceptance of a natural law system. And that thing is coming from two angles. One is from the common law tradition, that is more or less from let's say from the United States, and also from the civil law tradition, which is from Spain. Okay. So you essentially, in a way, if you could put it in a more frivolous way, natural essentially attacked us from both sides, and then it just coincided in the formulation later on of the various constitutions that we had. although I have to say constitutionalism in the Philippines started with the Americans. We never really had a constitution before the Americans came. And so when the Americans came, we had the Jones Law, the Philippine Bill, and so on. And then after that, when we became a republic, there was already built in, I think you could probably say written in the hearts of the Filipino because of all that years, all that culture and tradition of the idea of a natural law.
Right. So just in a closing moment, for someone picking up this book and reading this book, what would you want their major takeaway to be? How would you know you were successful in writing this book?
That when we made this Constitution in 1987, we had a certain set of values. Now, when you say that you're an originalist, it doesn't mean that you're conservative or liberal. It just means that you believe that this Constitution contains a text that was approved by the people in their wisdom when they ratified it. Now, it just so happened that this text contains a certain values that are more or less aligned with the natural law. And it's also, let us not be shy about it, contains a reflects our belief in Judeo-Christian beliefs that the Philippines actually shares. And that if we do want to change that, then it requires a asking the people first. But I think it's not something that we should assign to 15 lawyers to just immediately dismiss it willy-nilly. So I think it's the need to protect that belief that our people has expressed, and that expression is found in the Constitution.
Okay, well, very good. Thank you so much, Dr. Gatdula. Pleasure to have you on the program.
Thank
the book,
you.
Natural Law and the Limits of Judicial Power. Interesting read, published by Central Books. Look for the entire interview coming soon right here on the network. And don't forget to check out our YouTube channel and, of course, our on-demand platform as well. I'm Doug Keck. This has been an EWTN Bookmark. Thanks for joining us. We'll see you next time.